The start of deportation proceedings, for another term for that. So an NTA is definitely a big deal. Hi everyone, and welcome to another episode of Visa Vibes, your go-to source for everything U.S. immigration. I'm your host, Emily Newman, and managing partner of Reddy Newman Brown PC.
And I'm Stephen Brown, a partner at Reddy Newman Brown PC. And today's episode, we're going to talk about a new trend that's got everybody on edge, especially H-1B workers, where we're seeing it the most common. And we're talking about USCIS issuing notices notices to appear, or NTAs, even if they're within that 60-day grace period after their H-1B employment ends. This is supposed to be a protection window. The regulation kind of treats it like status, but instead we're seeing it turn into kind of this trap door where the employer's doing what they're supposed to, and then it's triggering removal proceedings.
Yeah, NTA, that is like the start of deportation proceedings, for another term for that. So an NTA is definitely a big deal. And in 20 years of practicing immigration law, I've never seen one issued to someone who was in H-1B status doing all the right things. So these are being issued even when the individual is in a period of authorized stay. In many of the cases, they've already filed a transfer to the new employer, or they've already filed a change of status to H-4 or B-2 or whatever option is available to them, and it's within the 60-day window. So it's just it's confusing for one, but it's also completely wrong. There's not many situations where USCIS gets things completely wrong, but this is just...
We've seen some where there's already something pending.
Yeah. So, our theory here is that this has to do with AI. And so we look at these notices to appear, and when you receive one, it kind of has this charging document where it goes through what you're accused of, we'll say. So it will list that this person had an H-1B with this company, with this receipt number, and then they filed this, and then they filed that. And then USCIS revoked the H-1B because the company filed a withdrawal request, and then the individual filed a change of status to H-4, which is pending. And then it says, because USCIS revoked, you have stayed longer than you were allowed. You've remained in the U.S. beyond the period authorized, which is completely incorrect. So we feel like this is just an AI thing that found the word revoked, didn't go the next step to determine whether the person was still maintaining status, even if there was something revoked, because there's a lot of reasons why something might get revoked. The bad reasons are fraud, misrepresentation, gross error, like the person didn't deserve it. Those kind of can make sense for let's go to a notice to appear. But for someone who gets a revocation because the company withdrew because the person is no longer with the company has to withdraw. They're required to notify USCIS. That automatically leads to a revocation. That revocation says nothing about the person. It has nothing to do with the company. It's just a procedure, an administrative procedure to close out that case. It does not have any impact on someone's status when they've already moved on to another company or another status.
Yeah, and it's about as ministerial as it comes. I mean, for years we've been seeing these revocations, and it's under the regulation, it's an automatic revocation when the employment ends and the company notifies. And that's totally fine. Nobody has ever worried about that. The first Trump administration, when they said we're going to issue NTAs, never saw it for that because it's not proper. And so what we think, all of these are coming with a charge, and correct me if I'm wrong, it's 237A1B of the INA, and it says, violation of this statute or had your visa revoked. And then it defines visa as, well, it doesn't define visa, but it says visa or other document used for entry. So it's defining visa as the visa stamp, the right terminology. And you can be subject to removal if you have a visa revoked. If the Department of State revokes your visa, you can be put in removal proceedings. And so what we think, and this is the AI part of this, is that it's seeing the system flag the withdrawn H-1B, that the I-129 is revoked, and either they're triggering it as, they're out of status and not doing any further investigation to see what's going on, which is problematic, or it's triggering revoked and assuming, visa revocation, even though it's an I-129 petition revocation, very different. It doesn't, you can't be removable even if, your case is revoked because it wasn't a specialty occupation after a notice of intent to revoke. You might be out of status, and that could lead to something. But again, they're completely messing this up. And like you said, this is a huge problem because when a company terminates an employee, and many companies do it as a practice when the employee even leaves voluntarily, but for sure, when they terminate an employee, they are required under Department of Labor regulations to notify USCIS of the termination of employment in order to go through the bona fide termination process and not be liable for wages. It's mandatory. It's not optional. Then they send their revocation. Okay, cool. But now they're sending NTAs for companies doing what they're supposed to. So this is something we have been seeing. We're going to kind of talk about this.
Yeah, I mean, they're completely missing the nuance, which everything in immigration is about nuance. There is a 60-day grace period. It's in the regulation. During that window, the person is still in status. It's not just lawful presence. It's actual, their status is continued for an additional 60 days after employment termination, as long as their I-94 is not expiring. And so completely missing out on that nuance. And even in cases where they've timely filed a change of status or timely filed a transfer to another employer, that period, now they're in a period of lawful presence. They're lawfully in the country, and there's nothing in immigration that says that person has remained in the U.S. beyond the period authorized, because they're still authorized.
Right. Under the statute, it's a period of authorized stay. It's not just this term we all make up. And, my initial thought on this, when we first heard the rumor about these, and then we saw them for real, we've seen a number of them for real. So it's a confirmed thing. It's not just a, Twitter rumor here. Was that, hey, the 60-day grace period is discretionary. Maybe that's what they're doing. They're denying that and then issuing the NTA. That's not what's happening. These are all happening almost immediately once the withdrawal is mailed a week later. The USCIS processes it. They trigger it. Some of these cases have had something pending before the NTA. In fact, all of them that we've talked to had something before the NTA, whether it's an adjustment of status or a change of status or transfer, whatever it might be. And so even for folks doing everything the right way, they're getting these NTAs. There is no adverse decision against them. And it's just, again, it's a system level flag, and then they get put to these removal proceedings. Now, I don't want to bum everybody out. There's going to be some good news in this conversation, but it's something I think people need to take very seriously, and we're going to talk about what the repercussions and all are.
Yeah, and we're not speculating here. We've actually seen these NTAs. We've got a group of people that have shared their documents with us, and we've gathered their information so we can kind of track what's happening, because this is happening all over the country. Now, is it happening to thousands of people? Not yet. No, we don't think so. But it's a sufficient number of people to be concerned about it. And I also want to point out, we've even seen this in cases where there was no termination of employment. So most of them, there's a termination, and the termination causes the withdrawal. And then we have the 60-day grace period. They've filed something, but they're still getting an NTA. But we've even seen cases where there was no termination of employment. The employee was properly maintaining status with company A, got a job offer from company B, filed a transfer to company B, got that approved, and then left company A, resigned, moved to company B. Not one gap in status, not one day of no working. And then company A properly withdrew the H-1B because he's no longer working there. He left to go to another company, and even that got an NTA. And these are two companies, household name companies.
Yeah, it's happening. And so let's kind of put this in a reality situation for our employers. A very common scenario we see is somebody's on H-1B. They get laid off. It happens. That's why they created the 60-day grace period and portability rules and all this stuff to allow for these things to happen. You file an H-1B or you file a change of status to H-4, and then you think you're good. You're following all the rules. You've talked to, Emily, you've talked to me, you've talked to all the immigration attorneys. You're like, everybody's on the same page. I'm doing the right thing. and then suddenly get a notice to appear for removal proceedings, for deportation proceedings, saying you've overstayed. That's the nightmare scenario people are facing. There's strategies that we're going to talk about, but it's something we need people to be aware of. We're going to talk a little bit about raising awareness like that towards the end of the episode as well.
Yeah, so what's behind all of this? It all boils down to a policy memo or policy update that was issued by the Trump administration in February 2025. This is policy memo 6020187. It sets forth the circumstances under which USCIS, which is a benefits granting agency,
Yes.
can actually turn into a deportation agency by issuing an NTA. Now, we had, as you mentioned, during the previous Trump administration, this same memo was put forth saying we have the power to issue NTAs, we being USCIS. We never once saw an NTA issued by USCIS during Trump 1.0, but during Trump 2.0, after this February update, now we're starting to see them. But here's the thing. They're not even following what the memo says, because the memo says the NTA should, for this scenario, there's multiple scenarios where an NTA can be issued.
Yeah, I think it's like 10 different scenarios, something like that.
So the one we're talking about, they require first an unfavorable decision by USCIS, and second, when that unfavorable decision is issued, the person is out of status or no longer lawfully present. So number one, we need to have a denial.
Mm-hmm.
And number two, we need to have a denial after the person's I-94 has already expired. Those are the two things. If those things happen, then USCIS could properly issue an NTA.
Yeah, so these NTAs not only like fly in the face of their other regulations, statute, common sense, which is a rarity, in immigration, but it goes against the policy they put forward in February because we haven't seen adverse decisions. In fact, we've seen positive decisions after. If we got to a situation where somebody filed a transfer, now they're beyond their I-94 because everything was tight, but they timely filed the transfer, then there was a denial, that's an adverse decision, and then NTA happened. Like that makes practical sense. And again, I don't even know if it makes common sense, but it follows the rules here. I think in the previous Trump administration, the worst we would get is saying like, hey, here's a denial. You are in jeopardy of getting an NTA. Make sure you depart. That's fair, right? Like, give people time to get out before you put them through this process.
Yeah, so back to our AI theory. We believe that when the I-129 is getting withdrawn, the system sees revoked and equates it with a visa revocation, which is not accurate. This is a petition revocation, and it's not a petition revocation due to any nefarious issue. It's due to administrative, this is how we close out a case when someone is no longer there. That visa revocation, they are then equating with loss of status, which is also not correct. It's not checking whether a change of status has been filed. It's not checking whether a transfer has been filed. It's not checking whether an AOS is pending. It's not seeing that the I-94 is unexpired. It's just automation, and there's no human, or maybe there are, I don't know, humans that don't know the law checking it.
I think you told me you even saw one where the person had left the country. Like they had gone, they were, going for stamping, they left, and now they get a notice to appear. Like, how do you appear?
Saying you've remained without authorization. How can you be remaining in the U.S. if you're already physically outside the U.S.?
So that's why we think there's a lot of AI and little oversight. So what's the fallout on this? Like, we're using this word NTA, but being issued an NTA is a major issue. One, we don't recommend you leave once you get it. You have to get permission from DHS to do that. So that's number one. So even if it's wrong, which is all the ones we've seen, I haven't seen one where I'm like, that makes sense. No. It puts someone in removal proceedings, which is the legal term for deportation proceedings. You're going to go in front of an immigration judge. It's an adversarial, procedure. We recommend getting an attorney who knows removal proceedings. I think Emily agrees, recommend a removal attorney who knows that area, that court, because many times these immigration courts, that's what it's called, even though it's just DHS, but it's called an immigration court, is very much driven by their weird idiosyncrasies, meaning the one in Houston might be different than the one in San Antonio, might be different than the one in San Francisco. And so their procedures, their liaison efforts, all that, that's why we recommend maybe getting someone local to that area. It can affect future visa applications, your green card processing, future travel. And so it is real world. We're seeing positive trends so far, but it's a big deal.
Yeah, so again, we've seen this where individuals have a pending 485, which means there's no unlawful presence. They are specifically lawfully present and being told that you're remaining without authorization. We've seen it for people who filed transfers. We've seen it for people who filed change of status to H-4, B-2, whatever it is. All of these cases, they should have never been issued an NTA. The good news is, as of now, several of the individuals have had their pending case approved after the NTA was issued. So we've seen H-1B transfer getting approved with the new I-94, showing that USCIS agrees that this person is in status.
Which is funny because USCIS said you overstayed, alleged you overstayed.
Yeah. So that tells you everything you need to know about this. The whole thing is just broken.
And we've seen at least, I believe, one instance where the NTA has been dismissed and one where the removal attorney said we're filing for dismissal because with the approval it would be dismissed. But let's talk, I don't want the vibes to be all bad, right? Kind of a miracle. You're talking to someone at USCIS who's actually responded to you, correct?
Yeah. So as soon as this started happening and we realized, okay, this isn't fake news, I started researching, okay, who do we need to get this in front of to, how do we get an adult in the room, as you like to say?
I do, yeah.
And so, I found a couple of different email addresses for USCIS that I've never attempted to use before. And so I emailed one, hey, this is going on. These are not right. You need to instruct your officers of the proper way to go about this. You're not even following, I said it nicely, you're not even following your own policy memo that says there needs to be an unfavorable decision plus an overstay, and you're not taking into account the 60-day grace period or lawfully present individuals due to an adjustment of status. They responded back and said, hey, can you give us more information about these cases? How are they, what have they filed, what's going on with the 60-day grace period? So I gave them some more examples. They had a couple of follow-up questions. Even today, I emailed back and forth with them 3 or 4 times.
Wow.
So, which is ridiculous,
insane response time for USCIS.
So the last email was that they are researching it. They're looking into it further. So hopefully they are understanding what it is we're trying to get across to them. We've done a lot of other efforts, but this is the first one where we've actually have a dialogue, and they seem to be taking it seriously. And
that is good. And like we said, the other good sign, one, if they are trying to fix it, let's be frank here. The removal proceeding process is severely backlogged in the administration's viewpoint, people who need to be removed. I'm not going to agree with them on that. Now we're talking about people who are following the rules. This is slowing down what they want to do, but we are seeing these approvals of an H-1B, an H-4, H-4 EAD after the fact, and that's a good sign because you can only get those if you've maintained status, right? And so hopefully this is going to fix itself, course correct a little bit, but this problem doesn't go away overnight.
Yeah, so what can you do about it? I mean, there's definitely multiple steps. There are things that you can do even if you haven't been issued an NTA or if it's not a concern for you. And there's other things you need to do if you've been issued an NTA. So if you receive an NTA and you're within the grace period, you've timely filed a change of status or a transfer or your 485 is pending, number one, get legal help immediately. Because these NTAs, as we're finding, can often be challenged, and we're being able to get them dismissed.
Yeah, and what we want, and what I think you and I, as long as we've been working together is how can we better the system, right? We've always tried to put things forward. And so Emily's put together some good template writing campaign and instructions for you how to contact your local congressman and senator, the Senate and House Judiciary Committees, the USCIS Public Engagement Division, the Policy Division, the Director's Office. Emily's got it all on a blog post on our website, rnlawgroup.com/blog. There is a post titled Holding USCIS Accountable, Stopping Improper NTAs, and we really encourage you to take these steps and fight for your own future.
Yeah, because we, again, this isn't impacting a huge pool of people yet, but as we saw with the CVIS issue with F1 students just a few months ago, it ballooned. Mm-hmm. We got 1, then we got 5, then it got 20, and then we found out it was 5,000 or 6,000 people that were impacted. Mm-hmm. We're trying to cut this off, nip it in the bud before it continues to blossom, and the only way to do that, besides people who've actually gotten the NTAs taking action, is for other people to get involved and ask their congressperson to actually oversee what USCIS is doing and realize that they're not doing it correctly. Ask USCIS to make sure they're following their own rules and just get somebody's attention. And the more people that we have reaching out, the faster we're able to get the attention needed and get this resolved.
Yeah, and we've had the question, like, why are we not suing on this? We're looking into it. When we talk about removal proceedings, there's giant jurisdictional hazards, and so we're trying to look into it. But I think it's really important that Emily's had that dialogue, and even if you're not an employee or an H-1B beneficiary, I think this could happen to any category at some point. I encourage employers and advocates that are listening to do this as well, because this is going to disrupt businesses. This is going to negatively impact people, and we just need to raise that awareness. So some final thoughts here. The grace period does exist. It hasn't gone away. I know I've had that question, like they archived that one web page, options for terminated non-immigrant visa workers, that I think archiving some of the policy guidance that they had under the previous administration, they can't archive a regulation. And it is designed to allow people to find new jobs, find new status if they need to, and this process is undermining everything in that.
Yeah. So we're going to keep watching this issue closely. We'll keep pushing USCIS for clarity and to reverse course on this. We're going to keep standing up for our clients and for the community. So if you're affected or you just want to share your story, reach out to us. You're definitely not alone. We are continuing to monitor it, and the more we hear from individuals impacted and what's going on with their cases, the more we can keep everybody informed, as well as hold USCIS accountable for their actions.
So that's it for today's episode of Visa Vibes. Be sure to subscribe on any of your platforms. I know we're on Spotify, Apple, YouTube, and share it with your friends and social media groups, and make sure to check our website for how to go about those advocacy efforts.
So thanks for listening. Remember, in immigration, details matter. So stay informed, stay alert, and stay in status.